Hello and welcome to Practical Law's in-house agenda for November 2017. I'm Sara Catley and I'm going to be running down the key developments that you should have on your agenda this month. One of the key developments that we saw in October, and something I think people will want to look at this month, is the final report of the PARCC review. The PARCC review was set up to look at ethnic diversity on UK boards, and in principle its recommendations apply just to Footsie 100 and Footsie 250 organisations. However, I think it's going to be interesting reading for a wider audience than that, because large companies, public sector organisations and the third sector will want to pay attention to what could be described as really a pathfinder for them as to how they tackle issues of ethnic diversity in their organisations. So John Parker says in his introduction to the report that he feels that a lot of progress has been made in the area of gender diversity, but we've really lagged behind in terms of ethnic and cultural diversity. Looking at the Footsie 100, for example, we see around 8% of directors being directors of colour, compared with 14% in the population at large. There's a real commercial imperative around addressing this disparity, because I think it's now widely recognised that organisations with a diverse workforce perform better generally than organisations that don't have a diverse workforce. And that applies right the way through the management chain of the organisation. So what does the report recommend? Well, there are three main areas where there are recommendations. The first are some concrete recommendations and guidance about the number of directors of colour as a minimum that Footsie 100 and Footsie 250 companies should aim for. The second is some recommendations about how companies should mentor and sponsor an ethnically diverse group of individuals through a process to provide a pipeline for those true leaders. And then thirdly, there's proposals around effectively subjecting companies to the antiseptic qualities of sunlight. So proposals to ensure that companies report on how their boards are composed, and also report on the steps that they're taking around meeting the diversity challenge that the report lays down. Three interesting points I wanted to draw out from the report. The first is to go back to the point about the wide audience for it. I think there will be an opportunity for larger organisations that are not in the Footsie 350 to actually think more broadly about how they want to tackle diversity. And that brings me on to the second point, which is, unusually for a report of this kind, the back end of the report makes quite interesting reading. There are some really concrete proposals, including an executive toolkit, that set out how a board and how executives on it might go about thinking about how they firstly investigate what their cultural position is, and secondly work through the challenges that they're going to face along the way to put themselves on a better footing going forward. Now, it seems to me that a lot of that advice is of general application and is going to be something that people really want to take a look at and figure out whether they too want to be blazing a trail in this area. The last point, though, is a slight word of warning, which is, I guess this picks up on an ongoing trend of the regulatory landscape for organisations becoming increasingly peppered with things like guidance notes, recommendations, voluntary codes that make the environment for the in-house lawyer looking to build a robust compliance programme ever more complicated and nuanced. But in this instance, I think it's been quite powerfully done, and I was really heartened to see the very practical and thorough thinking that had gone into it. Moving on, another interesting development in October was the publication of updated guidance on the preparation of Modern Slavery Act statements. These are statements made by large companies on their attempts to ensure that there's no modern slavery in their business or supply chains. An interesting feature of the updated guidance is that the Home Office is now recommending that even smaller organisations make statements similar to those required of larger organisations. And so smaller organisations might want to take a look at the guidance and see whether they can take steps to bring themselves into line with those practices too. much of the guidance is actually unchanged, but there are a couple of key areas to focus on. One is some revised guidance around child labour, which is worth looking at, and the other is the focus and attention on continuity of reporting and access to historic statements. And this, I think, resonates with Maricela Robles' recent blog for us on modern slavery reporting. She was very clear that reporting on modern slavery is a lifestyle, not a diet. You have to absolutely, as an organisation, live and breathe your policies and processes around this. And so the journey that you go on as an organisation needs to be something that can be seen in your modern slavery statements. A really interesting insight there, I think, from her. Next up are two related developments concerning how smaller companies hold larger companies accountable for the way they treat their debts. The first is the appointment of the Small Business Commissioner. That's significant because they're going to run a complaint scheme under which small businesses can take a grievance against a large business for failing to pay them. The complaint scheme was supposed to be in operation from October 2017. It's now going to be in operation from the end of 2017, or so we expect. But when it does come into operation, it will be possible to lodge complaints in relation to matters dating back to April 2017. So even a current dispute might still be looked at by the Commissioner. The related development, of course, is some updated guidance around the duty on large companies to report on their payment policies and practices. Couple of points in the guidance. The one key one to note is that there's some updated and expanded guidance on what it means for a contract to have a significant connection with the UK, and that's very important for reporting purposes. One thing I've reflected on thinking about the developments I was going to talk about this month is the fact that most of those developments relate to guidance, and many of the developments actually relate to recommendations that are voluntary and that don't push organisations to do something by legislating for it, and in some cases just suggest that people voluntarily comply with legislation that was passed for different organisations altogether. So I think it's really timely then that Richard Thaler won the Nobel Prize for Economics this month for his nudge theories, because I think we can see those playing out very much in the way that lawmaking is trying to influence organisations to reform themselves culturally in terms of how they tackle things like diversity, how they tackle modern slavery, and how they tackle the imbalance in negotiation position between a small business and a large business in relation to payments and supply deals. And finally, no agenda would be complete without GDPR preparation. And we've published a couple of interesting case studies this month, one from Pearson and one from RSA. They might be worth a look if you're operating in those sectors. Secondly, a heads up for anybody who hasn't noticed, the autumn budget is going to be on the 22nd of November, so look out for a lot of reporting around that. And thirdly, the SRA is conducting a consultation on some handbook changes that will affect in-house lawyers, which may be worth a look.